Inside the Law is presented to educate listeners in Monmouth and Ocean counties about legal issues. The opinions expressed by the host, guests, and phone callers are strictly their own and do not necessarily reflect those of Town Square Media and are not intended to be a substitute for personal legal advice from your own attorney.
Your questions and comments are welcome at 732-505-1160. Inside the Law, talk radio for the Jersey Shore.
Good morning, ladies and gentlemen. Welcome to another live edition of Inside the Law, brought to you by the law firm of Novy & Associates, proud hosts of the show. We've been doing it for over 20 years, and it's one of the many ways we like to stay connected with you, our listener, who are listening to us on WOBMAM.com, on 1160 AM in Ocean County, 1310 in Monmouth County, and all over the world on WOBMAM.com. Every week, we literally take you, the listener, inside the law to learn about a topic of interest. We also invite your questions, and we give you an opportunity to call in, and we literally take you inside the law to discuss subjects that, based on the years we've been practicing law here in Ocean and Monmouth County, which is approximately 90 years collectively, we like to address the shows that you, our listeners, regularly want to learn more about. With me today, please welcome a friend, a colleague, a son, and a new attorney at Novy & Associates, Stephen Tedeschi. Stephen passed the New Jersey Bar this last summer. He clerked for a Superior Court judge in Ocean County, Judge Arnold Goldman, and he joined the firm about 3-4 weeks ago. And Stephen is going to actually be interviewing me, and we're going to conduct a dialogue about elder law, estate planning, anything else that comes up. As always, if anyone listening to today's show has any questions, we invite you and welcome your inquiries. Call us at 732-505-1160. And as always, we encourage you to have a pen and pad handy because we give out important information, phone numbers, upcoming events that we're involved in, and much, much more. So sit back and enjoy the show. Good morning, Stephen.
Good morning.
So how does it feel to be a young lawyer?
So far, so good. It's a little nerve-wracking, but I can't complain as of yet.
How is it different than what you thought it would be when you went to law school?
They don't teach you how to do a radio show in law school, so this is a bit unnerving, but otherwise, it's a lot of legal theory, but not a lot of practical work, and that's what I'm learning now.
And do you know why Novy & Associates has been doing this show for over 20 years?
I have listened to the show in the past before I joined the firm, and I found it extremely helpful.
Well, thank you. We view it as an opportunity to kind of stay connected with our clients, many of whom are adults, mature adults, retired, and other people. And it's a way to keep in touch and keep informed and to stay connected. And we appreciate the input. We appreciate the questions that we regularly receive. And it's a way to keep people informed as to things that are going on and give people a chance to ask questions that in the past they were perhaps afraid to ask, and give them kind of a free opportunity to discuss issues over the phone, on the radio. And if after today's show, as always, anyone wants to come in for a courtesy consultation, we always make that opportunity available. So what questions do you have for us today?
Okay, well, just to start in general, as you know, we're both elder law attorneys. It's an elder law firm, but
even though you're not elder yet.
Not yet. But what specifically does elder law entail?
Well, you know, it's an interesting question. We get asked that a lot when we go out into the community. As you know, we do speaking engagements, and you don't have to be elderly or elder to have an estate plan. But in particular, elder law refers to elder law and elder care, including things like obviously having a will, making sure your will's up to date. Anyone listening to today's show who's 18 years of age or older who has any property, it might be a home, it might be a car, it might be furniture, it might be life insurance, it might be any of the above, should have a will, because a will is like a deed to your life. It tells us who you are, who you want it to go to, who you don't want it to go to. So you don't have to be, quote, elderly or over 65, which is not old today. It's young, actually. But everyone who fits that criteria should have a will. Elder law gets into that, but it also gets into things like health care. In the event anyone became disabled and needed someone to be a decision maker for them to deal with the hospital, to deal with the doctors, to deal with, should I go to the hospital? How long do I need to stay in the hospital? When I'm released from the hospital, can I go home safely? Do I need someone to help care for me at home? Can someone hire a healthcare home health agency to assist me in my activities of daily living? Those are questions that typically come up from a medical point of view. And what I've seen over the years is when you go to a hospital as an adult, mature adult, the first thing that the hospital is going to ask you is, do you have a Medicare card? And the second thing they're going to ask you is, do you have a healthcare proxy or medical power of attorney? And or do you have a living will? So that's part of elder law. Another part is, in the event any one of us listening to today's show, or even you or I, God forbid, had an illness, a head-on collision, or something happened to us, do we have a document that allows someone to pay our bills, to pay our mortgage, to get money out of our retirement account? If we had to sell our home and move to another community, or to sign the paperwork necessary to go to a nursing home, how can anyone do that for us? If we haven't signed a document known as a financial power of attorney, and we need that kind of help because we can't take charge of our own affairs, pay our own bills, and make those kinds of decisions, Steve, someone may have to hire a lawyer, go to court, and bring what's called a guardianship. And guardianships are expensive, time-consuming, they cost several $1,000s, and frankly, it's an invasion of privacy. So today's senior, today's mature active adult should take steps to protect and preserve what they own, to protect themselves and their loved ones in the event of illness and disability, and of course, to deal with what might happen in the future. So it's a responsibility, but it's also an opportunity to protect yourselves, to protect your loved ones, and ultimately to leave what I call a lasting legacy. And at Novy & Associates, we're all about allowing us to help you preserve and protect what you have. And that's really the best way I can kind of summarize what elder law is all about today. And it's constantly changing. As you know, our tax laws are constantly changing. Our Medicare, Medicaid laws are constantly changing. So it's in the interest of everyone, including our listeners here on Inside the Law this morning, to stay connected, to keep abreast of changes that are constantly taking place on a state level and on a federal level.
Great. And you kind of went over a lot there. That's a lot of information. Let's see if we can break it down for the listeners, specifically going back to just a regular will.
Okay.
Why is it important to have that will if you're over the age of 18, if you have some property? What type of protections does that afford you?
That's a very good question. First of all, most importantly, who do you want to leave your stuff to? There was a comedian, George Carlin, that did a skit about your stuff being your furniture, your jewelry, your car, your collections, your iPhone, your computer, your laptop, your iPad. Who do you want to receive those items later on when you're no longer here? Of course, you can give them away before you die, but most people don't do that. So a will is, like I said earlier, it's like a deed to your life. This is who I am. This is who I want it to go to. This is who I don't want it to go to. If a person in New Jersey, like other states, dies without a will, or a will that's up to date and currently reflects their current wishes, the state of New Jersey has laws called the laws of intestacy, and those laws will dictate who receives your assets. We recently did a talk the other day at Health South, and a woman came up to me after the presentation, and she said that her son had died without a will, and he was unmarried, he had no children, and she asked me who was the rightful heir to receive his estate, and it was considerable. I said the rightful heir under the laws of intestacy would be his mother, his parent. And she said, I guess I got duped by my own children. I said, what do you mean? She said, my children got together and said to me, Mom, you don't need it, so we're going to give you $35,000 and we're going to take the rest. I said, well, you did get duped because under the law, you as his mother were legally and literally entitled to get the whole. Now, if the son, if the mother didn't want the estate or didn't want it all, then what she didn't take would go to his brothers and sisters. If any of the brothers and sisters weren't alive, it would go to the nieces and nephews of those brothers and sisters. Now, again, how old are the nieces and nephews? If they're minors or young, the money would be deposited in a surrogate's court. Well, putting money in a surrogate's court is nothing wrong with it, but how about having a will that covers situations like leaving money to minor beneficiaries, whether it's children, grandchildren, nieces, or nephews? So those are just a few of the situations that can be avoided by having a will that's up to date. And, of course, last but not least, besides dealing with the personal property and who's going to inherit, how about who's going to settle the estate as executor? If a person doesn't have a will or doesn't name an executor, or the executor is not here because they have passed away before you, or is not capable because they have their own disabilities, and there's no one else named in the will as an alternate, someone has to go to court, post a bond, and be appointed as the administrator. And that involves more delay, more expense, and more time, all of which could be avoided by having a will that covers what you own. So that's why it's important for everyone, anyone that has property, to have a will. Folks, you're listening to 1160 WOBM AM here on Inside the Law. This is Bob Novy, along with my colleague and son, Stephen Tedeschi. And our phone lines are open. Our number here at the studio is 732-505-1160. Your calls are welcome. And, Paul, I understand we have a caller on line one.
This is Lori in Toms River.
Lori, thank you for tuning in to Inside the Law. How can Stephen and I help you?
Hi, Mr. Novy. We just moved from Pennsylvania to New Jersey, and we're wondering if we have to redo our will.
How long ago was your will done?
Maybe 7-8 years ago.
Well, we always like to recommend, on an average of every 5 years or so, to have your will reviewed. Simply because your will was done in Pennsylvania when you lived there doesn't mean the will is not valid here in New Jersey. If the will, when it was signed in Pennsylvania, was signed by you, witnessed by at least 2 people, and then notarized, the will is what we call self-proving, which means your executor won't have to look for one of the witnesses. So that's good if your will is literally self-proving. But some of the changes that may have occurred in your own lives are, does the will provide for grandchildren? If you leave everything, do you leave everything to your husband? He leaves everything to you?
Yes.
Okay.
We did not make any provisions for grandchildren.
So, and do you have children?
Yes.
Okay. So I presume your will say you leave everything to your husband, he leaves everything to you, and then on the death of the two of you, everything goes to your children?
That's right.
Okay.
Equally.
Well, in the event, God forbid, something happened to one of your children, you should consider whether, if something like that happened, would you and your husband want that son or daughter share to go to your daughter-in-law or son-in-law, or would you rather it go to your grandchildren, or would you rather it go back to your other child? So that's one example of what may not have been discussed and covered and anticipated in your prior will. Another issue might be, what is the difference in tax law between Pennsylvania and New Jersey? And are there steps that can be taken to avoid that tax exposure? And, of course, does your will name an executor who maybe is no longer appropriate? If your will was done 7 years ago and your children are older, rather than naming a third party as executor, maybe you want to consider one of your children as an alternate or a backup executor to you and your husband. So those are just, okay. So those are just a few of the examples that I can draw upon. And the last thing I want to say, Lori, if I may, is that life is constantly changing, like changes in our lives. People come into our lives as a result of marriage, births, adoptions. People leave our lives as a result of death, disability, divorce. And as I said a moment ago, our tax laws are constantly changing. So when there's a change in your personal family dynamics, it's a good reason to sit down with an attorney, have your will reviewed, And let me give you our phone number, and this goes to anyone listening to today's show.
I was going to ask if somebody, would you do that for us?
Absolutely. Our phone number at Novy & Associates is 732-657-0600. And if you would like to have an update, have your current documents reviewed to see whether or not they are still up to date and whether or not they still be valid and recognized in New Jersey, we would offer that as a courtesy consultation. And what we would do is send you directions to our office. We have two offices, one in Manchester on Route 571 and another office in southern Monmouth County in Seagirt. But either, depending upon which location is more convenient, we would sit down with you, review your documents, and if your documents are up to date, we do not charge for that initial courtesy consultation. And I'll just ask you to call our office. We'll make an appointment, and just remind us that you heard us on today's show on Inside the Law.
And can you give me the number one more time, please?
Sure. 732-657-0600.
Thank you very much.
Thank you for calling. Have a great weekend. We look forward to Steve and I will look forward to meeting you, and be well and enjoy the weekend.
Thank you.
Thank
you
you.
too.
Bye-bye. Paul, I understand we have a caller online, too.
Yes, this is Kay in Tom's River.
Kay, welcome to Inside the Law. How can Stephen and I help you?
Good morning. I was just, this topic is like right on point with what I'm thinking about in my life. But as far as the will process, and I'm on the younger side, what...
You had to rub it in, didn't you?
No.
Go ahead. I'm sorry.
No, I was just saying,
yes,
because I feel like I'm immature in my thinking as far as that. But I was just wondering, other than along the lines of naming an executor for your will,
yes,
what thought process could I use other than maybe the obvious of like a responsible child or, and maybe that's not the smartest choice. So I just wondered what your thoughts are on picking an executor for your will.
Well, Kay, my first question would be, how many children do you have?
3.
Okay. Do they all live in the Ocean, Monmouth County area?
No, 2 are in Virginia and 1 is in Ocean County.
Well, the first thing I would ask you to consider is the age and the maturity and the availability, the one of the child who lives the closest here in Tom's River, let's say. And do all 3 children get along? And you don't have to answer this, but that's one of the factors. And how capable are your children when it comes to managing their own affairs, paying their own bills? If you, as a parent, have loaned them any money, have they paid it back? If they're on a schedule, are they paying it back? Or if they're not, is that going to cause a problem or give you any cause for concern that when I die, is that person going to ignore that obligation or that debt that's part of it, may be one of the assets that your estate is entitled to? When an executor is supposed to do their job, once they've filed the will and they've qualified as executor, they're supposed to keep the other beneficiaries informed. By way of example, what should we sell Mom's house for? How do we divide the contents, the personal belongings that are in your house? Now, Kay, if you haven't given thought to this and you'd like to receive some guidance, you can call Novy & Associates at 732-657-0600. And you can request, among other things, a list of what are the duties of the executor. And also you can consider making out what we call a letter of instruction. And that letter can give advice to your executor on how you want to divide the items in your home. Who do you want to receive what ring, what watch, your car, your Hummel, your Laliques, your jewelry, things that may be important to you, and even arrange for the handling of your funeral. Steve, anything else you could think of that Kay should consider about how to choose an executor?
Like you said, just someone who's responsible, someone you can trust, and someone who's aware of all the laws and can handle all the responsibility. It's not an easy process, and you want to make sure it's someone who can handle it.
Exactly. And what I would recommend, Kay, is give some thought to that. People ask us all the time, if I have 3 children, should I name all 3 of them together? Well, that's a recipe for disaster. Because you're assuming, A, they all get along. If they don't get along now, don't assume they're going to have to get along later. It doesn't work. And B, it's like management by committee. If they don't all agree, we have an impasse like we do in Washington or Trenton. So I always I suggest naming one, name another as a backup. And if, let's say, none of the three are capable, or that's going to cause a problem with the other two, then you might consider naming somebody else, like a close, trusted friend, an advisor, even a bank trust department, or an attorney. It's a matter of who can do the job and who, frankly, who do you feel you can count on? But if you call us at Novy & Associates at 732-657-0600, ask for Jake Mason, our Director of Marketing, and Jake will be glad to mail you the duties of an executor, what do I own and where is it located, and also give you some ideas of how to distribute your personal property and give you what's called a sample letter of instruction. And that's available to UK and anyone else listening to today's show.
I'm going to do that, and I appreciate that, because you would normally think the oldest child or the local child should just be the one, but you gave me a lot to think about, and I'm going to call Jake. And it's Jake Mason, you said?
Yes, Jake Mason.
I'll ask for him?
Yes,
okay.
Please do, and at 732-657-0600.
Will do. Thank you so much.
Thank you for sharing your weekend, and God bless, and we look forward to meeting you in the future, and have a great weekend.
Okay.
Thank
Bye-bye.
you. Bye-bye. Paul, I understand we have a caller patiently holding on line 3.
This is John in Whiting.
John, thank you for patiently holding. Welcome to Inside the Law. How can Stephen and I help you?
Good morning, Bob. I have a tough one here because this has to do with my brother-in-law. Let me tell you what happened. Now, my brother-in-law was a policeman who passed away, but he left his pension benefits to his mother. He was unmarried. Now, his mother passed away, and he has 2 sisters. Both sisters passed away. Now, the pension fund money is still sitting there, waiting for someone to claim it. And when I called them up, they said I should start trying to fill out the papers of custodial. However, here's another thing. Both of his sisters were married, and they have we have nieces and nephews.
In other words, the sisters died, but they have children.
But they have children.
Okay.
And naturally, my wife has 6 children also, but she's passed away.
I'm sorry.
So now we have all these children, and no one wants to take the responsibility of obtaining these pension benefits that are sitting there waiting for someone to claim it. One of the nieces happens to be on Social Security benefits, and my brother-in-law, who's still alive, doesn't want to claim the funds because he says it will affect the pension benefits of one of his children.
And it might affect her disability benefits, for example, if she's on SSI.
Yes, that's correct.
Well, to start with the first point, John, that you made, is that the brother-in-law who died, the executor and the alternate executor is not alive and not able to file the claim to collect those pension benefits.
That's correct.
So it would come down to the next of kin, which would be a decision and a discussion among the various nieces and nephews. Because if the sisters died, between them they have different children, any one of those children has the standing and the ability to seek what we call administration of the estate. But what that means is among them they'd have to get along, have a meeting or at least a discussion, and decide who among them is willing to take the time to do it. And someone should, frankly, because otherwise that money's just going to sit there with the pension, the payer of the pension, might be the state of New Jersey, whoever accumulated those benefits for your brother-in-law.
Yes.
So someone in the family should, with the consent in writing of the others, they would have to sign what's called a renunciation or a consent where they don't want to act, and they're willing to allow one of these people, one of these nieces or nephews, to do that. That person would then go down to the surrogates court. Did your brother-in-law live here in Ocean County?
No, he was a policeman in Brooklyn.
Okay, so this would have to be done up in New York then. If he died, did he die in Brooklyn?
He died in Brooklyn, yes.
Okay, so someone would have to go to the surrogate's court up in Brooklyn and make the application, which could be done. It would just take the consent in writing of the other nieces and nephews. Now, we don't practice law in Brooklyn, but coincidentally, I have a roommate of mine from law school who is a New York attorney. So if you needed a reference or a recommendation, I can certainly give you his name and phone number. And if you need that kind of help, you can call us during the week at 732-657-0600. Ask for me or Stephen, either me, Bob Novy, or Stephen Tedeschi, either one of us, and we can get you my colleague's name, address, phone number, and perhaps he could give your family the guidance and advice that they might need. Now, as to your second point, which is also a very relevant question today, what if one of the heirs who is entitled to share in these benefits is on disability? Well, we can't make that person share in the benefit, and they might have an opportunity to sign what's called a disclaimer, meaning I'm entitled to a certain percentage of it, but I don't want it, and therefore it may not. It might be a way of bypassing and not affecting their own disability income that they're currently receiving.
I see. Okay, fine. Thank you very much for all that. I was just wondering.
Yes.
Since I did mention it to my brother-in-law that one of the children should do it.
Right.
We sort of asked around, and everybody's so busy working, they have no time, and they're saying, "Well, why can't you do it? You're retired." So I'm 89 years old,
God
and they
bless
want
you.
me to go do it. And I said, "Well, I don't even know if I have any standing. Do I have any standing?"
Well, not that you normally you wouldn't have standing as a brother-in-law, but literally, if all of the others were willing to consent and allow you to do it, the answer is yes, you could. The question is whether or not, and I'm not familiar with whether or not you can do it by mail, and that's where the Brooklyn attorney can advise whether you can do it by phone and by mail, or will you have to physically go up to Brooklyn, meet the attorney to be appointed, and that's Jersey would allow that. I don't know whether New York would, but if you call this attorney, he can advise you, and I know that you can serve as long as all the other nieces and nephews are willing to sign off and let you do it for them.
Okay, fine. Thank you very much, Bob. I will contact your office.
You're welcome, John. Thank you for tuning in, and have a great weekend.
Bye-bye.
Thank you.
Thanks, John.
Bye-bye. We have a lot more information to share, but before we do, I know Paul, our sound engineer, wants to share some important messages. Please stay tuned. And again, when we come back in a moment or two, please have a pad and pen handy because we have a lot of important information, dates, phone numbers, and other information to share with you. Thank you.
Is a loved one of yours facing a nursing home or long-term disability? It's a very daunting prospect that can leave you feeling exposed and unprotected. Have you figured out the cost and, more importantly, how you're going to be able to pay for this special care? Do you know whether any assets owned by the disabled person can be saved? Or will everything have to be spent to take care of your loved one? The simple fact is you need to know about New Jersey's Medicaid laws to understand all your rights. Don't feel badly if you came up a little short on these questions because the topics require expert help, which is why you need to discuss Medicaid planning and protection with a caring expert at the law firm of Novy & Associates. You simply won't do better than relying on the expertise, professionalism, and courtesy you'll find at the law firm of Novy & Associates. You'll find yourself completely at ease with the way in which they handle your affairs. Call the firm of Novy & Associates in Manchester at 732-657-0600 with a solid reputation for helping and protecting people like you. That's 657-0600. That's 732-657-0600.
Good morning. Welcome back to the show of Inside the Law, brought to you by the law office of Novy & Associates, your boutique elder law firm here in Ocean and Monmouth County. You're listening to 1160 WOBM AM in Ocean County, 1310 AM in Monmouth County, and all over the world on WOBMAM.com. Novy & Associates specializes in estate planning, elder law. We help people with settling estates, giving advice on tax issues, real estate issues, guardianships, Medicaid, and much, much more. As always, we welcome your calls. Your questions are timely and appropriate, And if anyone has questions, you can call us today at the studio at 732-505-1160. Every question deserves our attention, and we will answer it as time permits. But if we don't get to you today, or you're one of those shy listeners, and you have questions that you want to discuss after the show, you can call us at 732-657-0600. We'll send you whatever information you may need and or offer you a courtesy consultation at one of our offices to sit down and address your questions in a personal, friendly manner. With me today is Stephen Tedeschi, an attorney with Novy & Associates, a new recent addition who brings a new level of enthusiasm and knowledge to the firm, along with our other colleagues, Jason Wyatt and Douglas Hull. And I'm proud to say between us we have about 90 years of experience, so no question is too large, too small, and hopefully we could be of service. Good morning, Stephen.
Good morning.
Stephen and I are talking today about estate planning and elder law. And, Stephen, what's the next question you think our audience would like to learn more about?
Well, I know earlier we touched upon a lot when I initially asked you about estate planning in general and elder law in general. But before we move on to power of attorney and living will, I have one last question about wills in general, specifically, and this touches on what we spoke about with John, an executorship. So,
yes.
As we said, it's a lot of work, it's a lot of responsibility. Are there any fees associated with being given that position?
Absolutely. The fee of an executor is based upon the size of the estate, and it depends upon how the assets are owned or titled. But to keep it simple, let's say any of our listeners dies, a resident of New Jersey, and they have an estate of $100,000 or $200,000. An executor's fee is 5% of the first $200,000. So on a $200,000 estate, that's $10,000. The estate's $100,000, that's $5,000. That fee is based upon the size of the estate. Now, if the person dies in New Jersey and the estate is over $200,000 but less than $1 million, then the fee is 5% of the first $200,000, which again would be $10,000, and 3.5% on the excess over the first two, up to the $1 million mark. So the fee is based upon the size of the estate, and that's determined by state law. Now, does an executor have to take that fee? If the executor is doing the work, they are entitled to it. If they take that fee, it's a deduction that can be used against any possible estate or death tax. However, if the executor takes that fee, then they have to pay income tax on that income that they receive as an executor. So going back to Kay's point, she has 3 children. If she names one of them as executor, that person will receive something above or in addition to what the other 2 children would receive, assuming they're all equally named, to each get an equal share or a third. And sometimes that can cause a problem or ill feelings between the children. If my brother's executor, he gets that 5% and we don't get it, well, that's true because he's doing the work. So what I typically will see is if it's a close family relationship and everyone gets along and no one's causing problems, the executor, when it's a son or daughter, they may not take the fee because they don't want to take more than the others get, plus they don't want to pay extra income tax on it. But if they don't get along, or maybe it's not a close family, or it's a distant or a remote executor, or it might be a bank trust department or someone else, rest assured they are going to take the fee because, as you said, there is a lot of work involved. But don't be, ladies and gentlemen, don't be sidetracked by the fee. Consider more importantly, what are the abilities, what is the responsibility and the maturity of the person you're counting on to carry out your will, to honor your wishes, and to do it in a timely fashion. Timely because if there are delays involved, those delays, if there's taxes due, that might cause extra interest and penalties to be paid before the estate gets distributed. So that's a very good point. There is a fee, Stephen, yes.
Great, thank you. Now, earlier we discussed powers of attorney. I heard you mention a power of attorney. What is a power of attorney, and how could that be of benefit to someone?
Well, a power of attorney is a document which says, mostly it's considered for financial reasons. A power of attorney is a document which says if I can't, for example, sign my name, pay my bills, have access to my accounts at the bank, and anything else that I normally deal with but I might not be able to, who can I rely upon? Whom do I trust to step into my shoes and become my financial secretary? In the absence of a power of attorney, if someone was disabled or not capable or not available, someone in the family may have to go to court and be appointed as the guardian. So a power of attorney is where you, the client, say, well, if I need help like that, this is whom I trust to carry out my wishes while I'm alive. And there are generally two types of powers of attorney. One is in terms of when the power of attorney can be used. A durable power, durable means I trust the person and I'm comfortable allowing them to act and take care of my bills and make financial decisions today, tomorrow, at any time. It's a powerful document. Why would I make it durable? Well, maybe I travel a lot. Maybe sometimes I'm here, sometimes I'm in Florida or somewhere else. And if a certificate of deposit comes due and I'm not here to tell the bank what to do I want the bank to automatically roll it over at another 0.5%? No. Maybe I want someone to move that money when it comes due and the CD matures and put it somewhere else where it can do better than earning 0.5%. So that's why a durable power of attorney is more flexible because it's more available. The opposite of that is what's called a limited power of attorney, which means it could be used only in the future, typically only if I become disabled, which would normally require first a doctor to meet me, examine me, and sign a letter saying, Mr. Novy's not capable, he has an illness, someone needs to take over and pay his bills and manage his affairs. But it's important to have a power of attorney, whether it's durable or limited. And again, people ask, if I have 3 children like Kate, should I name all 3 together? Again, that could be a recipe for disaster. Or you could name all 3, but make it jointly or severally, where any one of the 3 can act. But if one acts alone, because the other 2 aren't here or available, the one who does act has to keep the others informed. So there's no one absolute answer for every situation. Another power that's optional in that power of attorney is, in the event of illness, should we give that person who you name as power of attorney the ability to make gifts every year? You can give away tax-free $14,000 this year to as many people as you want, sons, daughters, your neighbor, your friend, a charity. But do you trust the person to have that kind of power and discretion? In the event of disability, should the person who's acting for you on your behalf, do you want them to be able to take assets and protect them from a nursing home and possibly create what we call a Medicaid trust? So that's another option and power that can be included in power of attorney. So there's a lot of different issues and a lot of different aspects to it. But whether you need all of that or just some of those things, that comes out from the conversation that you have with your attorney. And that's, when we talk about a power of attorney, those are some of the issues at Novy & Associates we regularly discuss.
Now, if one were inclined to choose the same person as the executor of their will as well as their attorney in fact for their power of attorney, is that an option? Is it preferable to keep 2 separate people? What do you recommend?
I would often recommend the same person, because if they should have to act for you while you're alive and take over and manage your finances, you're kind of training them, and now they're familiar, more than likely, with what they have to do for you. And upon your death, as you know, that power of attorney ceases or dies with you, and then the duties of the executor rise to the surface. So if they're already acting on your behalf and helping you, it would not make sense, as long as they're doing a good job, for them to have to turn everything over to a total stranger or have someone else take over. So if the same person is competent and is doing a good job, I would say let them handle both. But that brings up another point, and that is, how does my executor know, how does my power of attorney know what I own? Where's my paperwork? If I own stocks and bonds, where are the stocks and bonds? Do I have them home? Are they in a safe deposit box? Are they with a broker?
It also goes along the line, with your will as well. How would your executor find your will?
That's a very good point. At Novy & Associates, we have a questionnaire. It's called What I Own and Where It's Located. And ladies and gentlemen, if you haven't filled one of these out, please call us during the week, or you can call now and leave a message for Jake Mason at 732 657-0600. And Jake will gladly mail it to you, or you could stop by and pick up a questionnaire called What Do I Own and Where Is It Located? Because that questionnaire will indicate if you have a will, which everyone I know will have after today's show. You can write down on that questionnaire, where is the original will? If it's in your safe deposit box, what bank? Where is the key to the box? Or do you keep it at home somewhere? Or does your attorney have it? So that will answer that question, Stephen, along with what does the executor have to collect? Because that's one of the first things the executor does once they're appointed by the court, which is what probate means. So the more information that you fill out now, it makes the duties of your executor a lot easier later on.
Great. Now, you had mentioned disability a lot when you were talking about power of attorney, which is a concern for all of us at some point. Are there documents or things that you can put in place at the firm for everyone that would protect you if and when you were disabled?
Well, among other things, absolutely. First thing is to have a financial power of attorney so that someone can pay your bills and make investment decisions for you. They can sign your checks, your income tax return, deal with Medicare, Medicaid if it becomes necessary, and things of that nature. Also, from a medical point of view, if a person, let's say, is in the hospital and is discharged and can safely return home, but they can't live alone and they need help with transferring from bed to bathroom and to kitchen and have their medications dispensed and their house looked after and someone to do their food shopping and so forth, part of elder law and elder care deals with having a plan in place to protect them in the event of disability. That financial power of attorney, along with the medical power of attorney, can include, among other powers, the ability to hire a home health aide or some kind of a caregiver, depending upon the level of care you need, to help you remain at home in the privacy and dignity of your own home, which we at Novy & Associates refer to as aging in place, and also to allow the person that's going to hire these people, allow them to have access to your funds to pay the bills, to pay for these caregivers so you can do just that. If you needed, however, if you couldn't go home because either you don't have enough resources to pay for that care or you couldn't safely remain at home because you need too many medical interventions on a regular basis, like a feeding tube or someone's terminally ill or whatever the situation might be, and it's just not a safe place or a safe environment to be at home, well, then the power of attorney would allow someone to arrange for you to enter a facility. It might be assisted living, it might be a nursing home, and allow that person to make sure that your Medicare benefits are in place and collected for your benefit. Your pension and Social Security are utilized to pay your bills, and if necessary, frankly, to be able to hire a realtor and sell your home and collect that money and use it for your care. Because after all, I always like to remind our clients, you are your own most important beneficiary. So it's a way of preserving and protecting what you have and living out your life in the least restrictive setting, in the comfort and dignity of your own home if that's appropriate, or if not, what other options do we have available to us? I just got a call the other day. A client of ours, a new client, was referred to us by a hospice nurse, and the woman's alone. She has a son who lives out of state, a daughter who died, grandchildren who were in college, and nobody, sadly, has the ability to help her in her time of need. And now she's on hospice care, and she's unfortunately terminally ill in her own home. Well, with the help of the hospice nurse, our client signed a medical power of attorney, a financial power of attorney, naming myself, Bob Novy at Novy & Associates, and we've interviewed and arranged for a continuing care agency who's licensed and insured to come in and provide her with the extra help that the hospice folks don't provide, helping her with her food shopping, her medication management. She's on morphine, making sure her home is cleaned. And because she has limited resources, we are arranging for a reverse mortgage to help pay for the care that she needs and let her live out her life with dignity in the comfort of her own home, which is what hospice can allow. And fortunately, she does have some resources that will allow her to spend her last days, as many as she may have, in her own home, which is what she wanted all along. So that's really what goes into elder law and elder care. And frankly, I'm proud to say that the staff at Novy & Associates have been trained, and we do have aging sensitivity because it takes special people who care to make these kinds of, to help family members and advise them on what their rights are and what options are out there, because this is not an easy situation. And as you know, Stephen, it's not something they teach you in law school, do they?
Absolutely not.
It's in law school, as you said, it's a lot of theory, but this is hands-on, everyday experience in life.
You're right. Now, I've noticed a lot of these documents have a common theme, which is basically to, one, give the client a peace of mind as to make sure their family is taken care of when they're gone. And it's also a way to help them along with the tough decisions. Now, I know a lot of people are concerned about those sort of final decisions of their own well-being and how to be taken care of. And you discussed earlier a living will. Now,
yes.
Can you explain what a living will is and how that can, again, help ease everyone's burdens with their family and as well?
That's a very good point. The issue of living wills and living, and I call it dying with dignity, really came about nationwide years ago with the Karen Quinlan case, where the young girl had a drug overdose, went into a coma, was in a persistent vegetative state, and she had no document that told her family what she wanted, should she be put on life support, and so forth. So the family had a petition at courts, and long story short, out of that and other decisions came what we now call our advance directive. So an advance directive or living will is a way of saying, A, if I'm not capable of speaking for myself in the future, and I'm in a end-of-life crisis, terminal illness situation, I, the client, am telling you, my doctor, the hospital, the caregivers, wherever I may be, and my family, what procedures I want and what procedures I don't want. And it literally says, among other things, while some of my choices may hasten my death or shorten my life, I do so because I value the quality of life over the quantity of life. And I don't want you, my next of kin and survivors, to feel the weight and the burden of these decisions or feel guilty about it. And I certainly don't want you to fight about it. I'm making the decisions so that you don't have to. Now, with that being said, if a person is in the hospital, as I said earlier, the hospital is going to ask you for a copy of that living will. Nevertheless, no matter what instructions you've written on that living will, in the future, if other decisions have to be made, the hospital, your doctor will still ask you. Your living will says do not resuscitate, do not keep you alive if you're brain dead, and so forth. Do you want us to honor that? So if the person changes their mind, they can say, you know what, I value life and I want to live as long as I can, regardless of what it costs. Or, no, that's how I still feel. I want you to honor and respect my wishes and carry out what's in that living will. So that's what that living will is all about. And I will recommend, folks, that if you have a living will, you should give a copy to your doctor or doctors. You should give a copy of your living will to the family members who may have to act as your decision maker. If you have a financial power of attorney, you should, of course, let them know you have it. You may or may not want them to have a copy, but if not, you should let them know where you keep it, along with the information of what do you own and where it's located. But the one thing I don't recommend is you should not give a copy of your will, even to your executor, and certainly not to the people that are named in your will as beneficiaries. Stephen, can you think of a few reasons why they may not want to give them a copy of the will?
Well, for one, sometimes you want to keep your will private, and you want people, to be a part of your life because they want to be a part of it, not necessarily for any financial reasons. So keeping that sort of information private may be to your benefit. Another reason, and that's a good point, another reason is, what if you get mad at someone or you change your mind and you want to either eliminate them as a beneficiary, which we all have a right to do if we're competent over 18 years of age, or what if you want to change the distribution and give one of the children or whomever you're naming in your will more than the others? But once you give your family or your beneficiaries or even your executor a copy of your will, even though you say it's private, don't open it, typically they do. And then they start to pass judgment like, Mom, why are you giving them the same as me? And you'll say, why not? I love you all equally. Yeah, but I have a larger family. You didn't spend as much on my education as you did theirs. He makes more money. I need it more than him. Or whatever the reasons are. Well, ladies and gentlemen, and Stephen,
whose money is it? Whose property is it? It's yours. And they don't get to vote on it. So you want to avoid that slippery slope of then having to answer and defend what you've done to your own family members. And ladies and gentlemen, just remember one thing. Confucius said, I never knew a person until I had to share an inheritance with them. So it's really no one's business. They should know you have a will. They should know where you keep it. But in all due respect, you know when they need to see it? When you're no longer here. That's what's called notice of probate.
Now, going back briefly to a living will,
yes.
I've dealt with clients already when I've done signings and things with them with their living will documents.
Yes.
And it's a question a lot of them have is specific to the living will. Any of these decisions I make, I do not resuscitate for any reason, any of those decisions in the living will, they ask all the time, does that cover pain management? Does that cover medication? They're afraid that by having a living will, a doctor will not give them any medication and prevent their pain, and that concerns a lot of them.
Oh, absolutely. And in the living will, it says, if I don't want heroic measures, nevertheless, I still request that you respect my privacy, you respect my hygiene, I still want pain management, I want palliative care, keep me comfortable, and a living will does not prevent you from receiving that. Quite the opposite. As a matter of fact, now there's a new procedure in New Jersey and elsewhere called POLST, P-O-L-S-T, Practitioner-Ordered Life-Sustaining Treatment. So if a person is terminally ill in a hospital setting, the doctor should discuss those issues, pain management being one of them, and other options that can be supplemented along with the living will. And if the patient expresses their wishes, they will indicate that to their doctor, and the doctor will actually issue an order that goes on the chart at the hospital. So that's a very good point. I want to just say one other thing, if I may, because we only have about 4 minutes left, and that is people ask us, how do we stay connected with Novy & Associates? How do we keep informed as to these constantly changing issues? Well, there's a number of things. Number one, if you're a client of Novy & Associates, as always, and even if you're not a client, we always recommend or always offer a courtesy consultation, as Lori, our first caller, asked about having a will reviewed and see if it's up to date, even though we didn't do it initially. We always offer that as a courtesy to our listeners and people we meet at speaking engagements. Secondly, we have a newsletter at Novy & Associates. We send it out monthly. If you have an email address and you want to be added to our newsletter electronically and you want to be kept informed as to changes in the law and upcoming speaking engagements, all you need to do is call Jake Mason at 732-657-0600, or you can send him an email or a text at jmason, that's jmason, at novylaw.com, and Jake will be glad to add you to our electronic newsletter. And if you don't want to receive an email copy, you can call our office again at 732-657-0600, and we can print one and mail it to you on a monthly basis. And as always, please feel free to view our website at www.novylaw.com, because you'll learn more about our respective backgrounds, the other services that we provide. You learn more about Stephen Tedeschi, our newest and brightest young attorney, upcoming speaking engagements we're doing, and future shows of Inside the Law. And similarly, we have an archive or a library of about 4 years' worth of prior broadcasts, so you can also look on the website and download and listen to a past show on some other topic that might be of interest to you. Steve, we have 2 minutes left. In the remaining time, anything else you want to discuss or ask me or remind our listeners about?
I actually just had one more quick question
Yes.
for you. I heard you mention a number of times throughout the broadcast today, aging in place. Can you briefly describe that term?
Sure. Aging in place is something that we all want to do today, which is after working as many years as we have, we want to enjoy the fruits of our labor, preserve and protect what we have, and live out our lives with dignity, in comfort, and enjoyment in the privacy of our own homes if possible. And if not, how can we enjoy that quality of life, and what options are out there if we need help with transfers, with food shopping, medication, whatever it might entail. And Novy & Associates offers aging in place advice along with folks that are part of a resource known as the Senior Resource Alliance. So if anyone would like to learn more about how to age in place, call Jake Mason again at 732-657-0600, and he can mail you some information about Aging in Place and the Senior Resource Alliance, which is a not-for-profit organization which includes various professionals who specialize in dealing with senior issues from a legal, financial, tax, medical, and home health, and even real estate point of view. And lastly, we're out of time. Stephen, thanks for coming on our show. Ladies and gentlemen, we'll be back in 2 weeks with another edition of Inside the Law. God bless and be well. Bye-bye.